This is the March 31st, 2009 meeting of the Rules Committee called to order. Roll call, please.
Member Johnson?
Here.
Member Johnson present. Member Chu?
Here.
Member Chu present. Member Chen excused. Mr. Chair, there is a quorum.
I'll go ahead and call agenda number 1, the approval of minutes of September 10th, 2009.
I don't have any changes.
No changes.
I move to approve the minutes.
I second that.
On the motion, Member Chu?
Aye.
Member Chu, aye. Member Chan excused. Member Johnson?
Aye.
Member Johnson, aye. Mr. Chair, there are 2 ayes.
Moving along to agenda number 2, reconsideration of bylaws, action item and attachment. Wait, is there public comment on number 1?
Oh, yeah, sorry about that. On the minutes?
Seeing no public comment, we'll move to agenda number 2.
So regarding the packet contents, we have the amended and current, we have the recommended bylaws by the Rules Committee of September 10, 2008. Did that never pass?
That did not pass.
Okay. And the changes that were made were in the notes, right?
That is correct.
Okay, I remember that meeting. And then number 3, we have a recommended by EOT. Now, that's their mission statement. That's not
That's
part
the
of the...
mission statement, part of the bylaws.
That is part of the bylaws?
Yes.
So each mission statement by each committee is a
committee,
part
yes.
of the bylaws? Okay, I didn't see that in the original document. So we need to approve it here. Was it just approved by the task force, or it needs to?
It was approved by the task force on the 24th.
Okay,
So do we need
Through the
to
chair.
approve it again?
We do not
No.
need
Okay.
to approve it now. It's already approved.
okay. Good.
So action item number 3 has already been approved.
Right. So we can go through this part by part. We could also take the issue of this first, just in case it's most interesting to the public.
Yeah.
So however you want to handle it.
The question presented is the Sunshine Ordinance Task Force subject to the requirements of Charter Section 4.104? Maybe that's something that we should move to the full task force.
Well, let's talk about whether we think it's even legal.
Yes. Okay.
It would be a revision to Section 7
Okay.
of the bylaws, which is on page 13 of our packet. And the city attorney's office is now saying it's not legal, and has always said it wouldn't be legal for us to do that. Is that correct?
That's correct, and this was discussed before the full task force during the Alan Grossman complaints. And at that point, the task force decided not to amend the bylaws, but recommended a rule change that if there was less than 9 members present during a task force meeting on a complaint, that there would be some automatic request for continuance would be considered or granted. I mean, I think that was one of the concessions made during the Alan Grossman discussions. But this definitely has been before the full task force in 2007.
And the full task force found that it would not be legal to do it.
That's correct.
Okay, and then the idea of less than 9 members present during a meeting, during a complaint, and all that never got integrated into our bylaws. I don't think
it
I didn't see
no,
it
I
in
don't
there.
think that ever became part of the bylaws.
Okay. If we made this change, essentially we'd be open to litigation.
Say that again.
If we made this change and we'd be going against the charter, we'd be open to people suing us for being against the charter.
If you were to do this, you would be going against the charter, and your orders of determination may have less weight than it currently has because it would be in violation of the charter.
Okay. I do have a couple questions about the analysis from 2007. Ernie?
Yes.
It seems like it all rests on this idea that Section 4.104 says each appointed board, commission, or other unit of government of the executive branch, where it says of the executive branch in one part of it, and B does not say of the executive branch.
Correct, in the other part.
Do you think that that was intentional? Or do you think they just left out?
I don't, I think that there, I mean, and I think that that's, the judicial construction, how courts look at it, in cases that have looked at these type of issues before, have found that if it is in one part but it is not in another part, that you can't assume that this was a typographical error, that there was an intent made in that. And I think that there was a case cited in the opinion that stated that. Maybe
The
Dibbs
Dibb?
case? Yes.
That seemed to have something, DIB seems to be about the definition of what a public officer is.
Right, you're
I
right.
mean, unless I'm reading that wrong, that
No,
doesn't seem to
that's
address.
correct. That's just to a public officer. But I think Brown versus Kelly Broadcasting Company was an old case cited in the opinion, in the analysis.
Is that in here somewhere?
Yes, it's
It's,
in page 4 of the opinion,
Analysis down.
Analysis, yeah.
analysis. Right in the middle.
Right.
It is a well-recognized principle of statutory construction that when the legislature, or here, the electorate, has carefully employed a term in one place and has excluded it in another, that term should not be applied where it was excluded. Brown versus Kelly Broadcasting Company.
Mm-hmm.
Then it says, while the task force is not specifically named a board or commission,
Right.
it clearly falls within the same class of entities. It is a formally established multi-member body existing as part of city government to conduct city business or otherwise exercise part of the city's sovereign power.
How does this issue affect any other board, commission, task force? And
I
how
mean,
does it?
the rule is uniformly applied as far as the quorum, as far as voting on motions.
And so nobody else is
It's,
bucking the trend. So, what about committees? Alan Grossman in August of 2008 made an argument for committees allowing majority vote of the members. Do we know how the board does that?
committee, I mean, you're talking about committees, usually it's a committee of 3 or a committee of 5. Are you talking about votes taken by the committee versus?
Yeah, votes taken by a committee. In this case, it was a Compliance and Amendments Committee meeting where they were, I think there's 5 people on that committee at the time. No, 4. And they were voting on whether to forward something to ethics or something.
And they felt that
And it lost because,
only 2 voted for it?
right, 2 voted for it, Philpa voted against it, and Erica wasn't there. And so Alan made an argument that we could change our bylaws to at least allow this at committee level.
Well, I think my opinion at that time was that in order to assure uniformity, that I would still stand by the idea that it should be the majority, even at the committee level, majority of the committee. I
How
mean,
does, do you know how the Board of Supervisors handles it, committees?
Well, if there was a majority, if there were 4, then the majority is 3. If there was a committee of 3, the majority is 2.
So even like at the Budget Committee where they have 5 people,
Then it would be 3. One more than half.
I don't know, I don't see how we could do this.
I got a question. So I guess basically the 4 people in the committee, right?
In the CNA committee, yeah, in
Yeah.
August.
Isn't it supposed to be like 5? Same thing like, the rule of, like what Ernie said.
No, I think at committees it can be anything more than 2 and more. It just depends on how many people have been assigned to that committee.
Hmm.
Does that make sense?
So you have, I guess, in Board of Supervisors, have you seen 4?
People?
Yeah, in the committee?
Well, I think there's
It's always
5
an
at,
odd number, right?
5 at budget right now, I think.
11 members, and if they have less than 6, they use quorum.
Oh, you're talking about committees, or you're talking about?
Yeah, committees, like Rules Committee, 3, right?
3.
What else? I think it's 5 for Budget and Finance, right?
I think it goes up during budget season.
And
the
then
number.
it goes
Through the
on and
chair,
up.
the exception is the Finance Committee and the Budget Committee as budget season approaches.
And then, so there are almost always 3.
Always 3, yes.
Okay.
So it's always 3 and 5, right? Or 3 and...
Right, and,
Right.
and that, at that case, that CNA, there happened to be 4 people that were interested, and 4 people were on that committee. I don't think we've ever really looked at, I mean, maybe we should, at,
Yeah.
limiting or being strategic about the number of people we put on any particular committee,
Or put odd numbers of people.
if we can get odd numbers interested.
So according to this memorandum, we're not our own separate charter. We can't make adoption of our own rules, right? And the Rules Committee can only make suggestions to the whole task force about amending its bylaws.
No, essentially, we can make our own bylaws as long as they're not in violation of the city charter.
Okay.
The city charter is like this overriding thing, and as long as we stay within what they say, and what this is arguing is that this would be we'd be essentially trying to usurp the charter, and we can't do that.
Yeah. So we're at a.
But I think the question is whether this Rules Committee can make the rules that bind the full task force without it going before the full task force. I think you can't. This
no.
is basically, you promulgate it here, you have hearings, you make recommendations, you have
Yes.
full discussion at the full task force, and they vote on it.
So it sounds like there was one suggestion that might help this made in that meeting. Ernie, could you say that again about the 9?
I have to look at I think it was in Mr. Grossman's letter.
So when this was discussed, they came up with an idea that might help alleviate the pain, which would essentially give the complainant the opportunity to go to a rehearing, to
45-day.
to waive the 45-day rule and ask for it to be heard at a time when there's more members present. If there's less than 9, it sounded like. Which is something we
This
could
is,
do that I didn't today.
This is a letter from Mr. Grossman dated March 6, 2007, and on page 2. This is what, I'll preface the section he was recommending to this. However, assuming that the city attorney's office is correct, a change in the bylaws to allow a simple majority cast to approve substantive matters is not possible for the SOTF. However, there is a way to ensure that the effect of the absolute majority requirement is minimized, while at the same time to be fair to all parties concerned. This is what I propose. Amend the bylaws to provide that if at any time during an SOTF meeting the number of members present and able to vote on a substantive matter is less than, say, 9, that the matter will not be heard unless both the complainant and respondent agree to have it heard. If either of them is not willing to have it heard by the number of members present, the matter is automatically continued to the next meeting, and any minimum period of hearing complaints is waived. Only one section of the bylaws need be amended, and it could be done quickly, requiring no more than 2 successive SOTF meetings. I would be happy to draft a bylaw amendment if that would help.
Was this presented to the task force as an amendment to the bylaws?
the email
No,
to
I
us?
think this is part of correspondence that is going back and forth. It wasn't presented to the task force.
Perhaps we should make that suggestion.
Yeah, so if we have 11 people in our body, right? We're 10. Actually, we're 10 right now, right? Because we're actually 10.
That means we have to have 9 people attend.
No.
No?
Six.
6.
6 is a quorum? Okay. But this rule would say that we would have to have 9. Only one person could be missing at any given time to hear it.
This charter.
With this change to it
Oh,
that he just described.
do we want to do that?
I don't know, one person. I mean, I think we get really good attendance, but one person gone is. And we've had trouble keeping that seat filled, that
Yeah,
one
that's
seat.
really hard.
Yeah.
to do that.
But I don't know if it's helpful to do it at 7. Ernie, what do you think about the idea?
I think that administratively it might cause problems because I don't know, you may have some member, you may start off with 10 and you may lose 2 members and then you'll have, later in the meeting, you may have 4 complaints that have to be rolled over till the next meeting. And there's no guarantee that at the next meeting that you won't have the same problem, you know?
Well-
it means we wouldn't be able to meet. We would just keep.
Exactly. Well, they wouldn't have to be rolled over. They'd only be rolled over at the discretion of
The
both parties, right?
If one of them doesn't want to hear it, I mean, usually it's the applicant, the complainant. If the complainant doesn't want to hear it at that point, then it gets continued according to this proposal.
Oh, so it's either party, not both parties. I'm sure it's probably either. I'm sure it's either party.
I think it stands better this way.
Yeah, if either of them is not willing to have it heard by the number of members present, the matter is automatically continued to the next meeting. And historically, it's usually the complainant that would make that request. I don't think that the responding agencies would have normally asked for continuances if they show up at meetings.
You know, the whole thing seems unfair, but just because of the nature of the work that we do. But at the same time, we can't go against the charter. I mean,
No, I
The
think
best thing we
it's
could do is go
better
to the-
have a quorum and allow people to meet and be heard, even if people are absent. They may have to win the vote of 80% of the people on the committee there. If there's 1 or 2 people out,
right.
then
Versus
and not go
66%.
against the charter,
Right.
and versus
Right.
adopting that bylaw.
And the only way to change this would be to get the Board of Supervisors to change the charter?
Sorry?
The only way to actually fix this is to get the Board of Supervisors to change the charter?
Yes.
I mean, it can't be changed in the amendments to the Sunshine Ordinance.
No, no. Again, the charter is the law that, in as far as the city, that controls other laws.
And how many Board of Supervisors we need to, get that amended or charter amendment?
Well, it's 4, to get it on the ballot.
Oh, it's 4 then. Okay.
If your amendments to the Sunshine Ordinance includes a charter amendment, as opposed to just changing the ordinance. That's the question. Are you going to change the charter?
I don't think. I think it would make the charter look messy to say, except for, regardless of them not changing it. So I'm not sure that I'd be interested in taking action on this part. Okay. I think there are as the bylaws go, there are other changes. Do you want to take public comment just on this specific text matter? Because
I'll open up agenda item number 2 to public comment.
Good afternoon, members. Anonymous tenants here. I believe Grossman, he said that the the Sunshine Ordinance Task Force is a separate entity. So therefore, you can make up your own rules and change your own rules. They're not governed by the city charter and stuff like that, according to Grossman. I don't know. I haven't checked into it, but I will look into it. Since you're a separate entity, you should be allowed to make changes. So, food for thought.
So from the bylaws, there are some other things I think we'd like to change. One of them is the name of the EOT, or
which, didn't we do this at the full task force meeting?
we made the change in their section of it, but we didn't make the change in the bylaws.
All right.
So I think that's on the bottom of page 18 of our packet.
Yeah. What formerly used to be the Public Education and Information Committee, it will be now changed to the Education and Outreach Training Committee. Page 18, bottom.
And we'd also like I'd like to change it in the bylaws to allow orders of determination to be forwarded to both the EOT and the compliance and amendments. And I'm not sure what that text would look like.
Is that also in here?
That would be, I think that, where page 19, compliance and amendments, it says, the Compliance Amendment Committee shall monitor compliance with the orders of determination adopted by the task force. So I'm not sure whether we just need to change the EOT's
Name.
B, number 18B, and say the EOT may monitor compliance with the orders of determination adopted by the task force. I mean, maybe that's it, is we change D, line 10 to may, and then add that same sentence into the EOTs under, line 24, 25 of page 18. Would that work, Ernie?
Send it either to EOT or to CAC.
Are you guys comfortable with that?
Perfectly.
We have been doing that already, but we needed to fix that.
We need to make it concrete.
Yeah.
Do we need to have a motion on that, or do we just?
I think we'll have a motion on all the changes,
Okay.
at the very end. Section 9, which is order of business on page 14, that doesn't seem correct. Well, actually, maybe it is, except for the report of the chair.
Section 9.
Page 14.
Yeah. 9. Oh, section 9.
Yeah.
Order of business.
I mean, actually, that is. Do we need to have this in here? Or it seems very specific.
I don't know whether you need to have this order of business, actually, because that's not exactly how your meetings are done.
No.
No, and we often take public comment at 5 o'clock, so.
I would be happy either getting rid of section 9 or saying the order of business at task force meetings may be, which I'm not sure why we would have bylaws that were unspecific.
I like may, because I believe that people need to have an understanding of what to expect in a certain way.
Right.
So,
And we're pretty close to that, but, well, we probably should add something in here that talks about,
There'd be something on hearings on complaints.
yeah. Should we replace that with a report of the chair? Because we don't seem to do a report of the chair. How would you word it? Hearings and complaints?
Right. Hearings of complaints forwarded, hearings of complaints filed with the task force. That would be jurisdictional hearing and then the full substantive hearing, hearing on the merits. And usually the report of the task force administrators later in the agenda
Is not a part of, what'd you say?
is usually heard later in the agenda.
Oh, yeah. So we should move that down. Oh, yeah, you're right.
I'm going to suggest that Section 8 on page 13 be amended simply because the laws changed based on Supervisor Alioto's Proposition B that passed.
Okay.
The section says teleconference participation is not permitted. Actually, it is now permitted. So I would say that teleconference participation is permitted as provided by Section 4.104 of the Charter. I don't know if it applies to anybody on the task force, although probably it might have applied to Erica Craven at some point, but
Should have required her to continue working.
if she wanted to call from home if she was caring for her child.
Right. Is that, what else does it say? Just caring for a child or
Yes, just caring for a child.
just?
It's a specific section.
Wow. And that went to the voters?
Yes, it went to the voters.
God, I can't believe the stuff we vote on.
Yeah, I think we should do a charter amendment.
Yeah.
Deal with members' pregnancy, childbirth, or related condition. So it's pregnancy, childbirth, or related condition.
Did she do that while she was pregnant?
You don't know.
Okay. Never mind. Chris, is there anything else that you think the bylaws should address?
Through the chair, I don't see anything at the moment.
We should probably look at the suggested changes in the document that was starting on page 21. Looks like the first change is on page 24 of our packet. I'm not quite sure what changed. There's capital L, I think. I don't know how to read these change things. See the bars on the side? I think that suggests that there's
Line 15.
line 15 has changed somehow. Capital L.
It's up, I believe.
You think that's it?
The main thrust was, I believe it was section 10 that member Bill Bell then wanted to change.
Do you know what the Robert Rules to Order is?
Mm-hmm.
So do you think this is in contrary to us being a separate entity or charter?
Robert Rules is just it prescribes you call a meeting to order, you hit that thing, what are the other things? I mean, it's sort of it's not substantive in any way. It just sort of talks about how a meeting is run. That the chair calls them a person before they can speak, that kind of thing. It's
I'm
a
just
book.
like, this threw me off a little today. You too, right?
Yeah, it's a big issue. And, but was Robert's Rules in the first one?
It's online.
The one we're working on? Yeah, it is, sorry. Okay. Oh, it looks like they had changed that order of business also. No. They had already made that change. On page 26.
Okay, yeah, so we've already made that.
Chris, do you know how the hearing to 10 changed? Section 10?
He just moved the section, I believe, to 11.
Oh, okay.
Yes.
He moved the 2 paragraphs, into section 11. Oh, I see.
He moved 2 paragraphs.
Okay, so he didn't actually change the content.
Now, on page 27, is that where you would like to address referrals to EOT? Because it says the complaint committee and the full task hearing complaint shall follow the following procedures. Or would that fall under
No,
16?
No, I think this is just talking about the process of a complaint when someone comes up in front of us. Because the same process happens at the complaint committee and the full task force. So, I mean, I know what you're saying, but I think... So I think actually a substantive change that they made was on page 30, Article 5. In the event a committee does not meet for a period of 6 months after its last meeting, the minutes of that meeting shall be agendized for the full task force for review and approval. I remember that. That's a good one. It means sometimes, like today, we met the
September 27th.
Yeah, that was a while ago. And the people that were at that meeting aren't here. Well, except for Hanley and I were here. When we approved the meetings of September 10, 2008, which was more than 6 months ago.
Oh, yeah.
And according to this part of our bylaws, those minutes would have come to the full task force for approval after 6 months.
Which would have been 4 days ago.
4 days ago?
Which, yeah.
Oh.
Oh.
So I think that, should we add that to are the changes that we recommend?
Yes.
Okay. Chris, did you go through and put in tabs here? Is that what all this stuff is? A tab before everything? On page 32, they changed EOT also. And it looks like page 33 had a substantive change also. The task force shall give 10 days notice prior to final action by posting on the Sunshine Ordinance Task Force website and by sending a copy to the Public Library Government Information Center. That sounds like we should add that one in.
Now, on the next page, is this one that's been brought up before, 2000, 2002, 2008?
Those are times that bylaws had been amended, and this
Just
proposed
Okay.
90308 did never happened.
Okay.
Because I think David Pilpel was no
Right.
longer around, and then neither Hanley or I brought it to the,
I was appointed in October officially.
okay. Oh, yeah, you took a seat. Yes.
So,
In more ways than one. He was chair of the Rules Committee, yes.
I had big shoes to fill.
So I think we should bring that forward too. The posting thing. Oh, I don't know what that was trying to address. Does anyone remember?
I think that bylaw changes were considered so important that there should be even more notice given to the public, rather than the regular notice given for meetings. So I think that was the intent.
So these changes would go to the task force, the next task force meeting in April, and then they would get posted for 10 days, and then they would go into effect.
The proposed changes would be posted 10 days prior to the final action posting by posting on the task force website.
It would be on the 14th, 10 days prior to.
24th, right.
So really,
18th, right, okay. So our final vote would be at the next task force meeting, theoretically. I don't see any other changes that,
So you're recommending to leave that as it stands, right? Is there anything that needs to be adopted in the bylaws for the task force order of determinations when they refer things to EOT rather than giving yeah, CAC? Because it says it's just recommended after it goes from the complaint committee to the task force for their order of determination. Is anything specific in our bylaws that need to be written in and posted about the changes that have been ongoing, where some orders, some items have been referred to EOT instead?
Well, what had happened was there were cases in which there wasn't an order of determination finding a violation. There were cases where you would have either no action taken because no motion passed, where there is like a request that the chair write the agency and urge them to do something, or it may be a situation, like I said, that the body doesn't want to vote for a violation but wants to have contact with the agency to educate them about the issue. And that's where the development of the EOT came about, that short of finding a violation, they see enough of a concern to want to get it to EOT to help educate people in that department about potential problems. That's how it went. Where we've now evolved to a state where there's actually a violation, but the violation may not be as egregious as other violations, and therefore we want to send it to EOT versus CAC. So, I mean, that's how it's been evolving now over time.
May I suggest discussing this issue in item number 3, because item number 3 is the complaint procedure. And if you look at page 44, line 3, it addresses the issue where you can see Senator Ordi.
can we take both these items together?
Yes.
did you want to, like, vote on the amendments to the bylaws and then vote on the changes to the complaint procedure? Or did you want to just discuss all of it and vote on it as one package?
I don't know. I mean, my only concern about taking them together would be that if we decide to make one change that affects another. But we can open up can we open up an old item?
Can we open up?
If we go through the complaint procedure and we say, oh, okay, wait, we need to make this change in the bylaws to support this.
Well, what you could do is you could finish your discussions on both documents and then either vote them together or vote them separately. But you could,
Okay.
you can now move to the next document without voting on the first one right now if you want to have leeway.
Let's do that.
Okay. Before we talk about page 44, so, Ernie, is order determination the right terminology for something that doesn't find a violation or finds a violation and sends it to EOT? Because it sounds like there's three things we do. Well, there's four things we do. We either do nothing, which we've done before, because if a vote doesn't work out or just because we choose not to do anything.
Or no jurisdiction.
Or no jurisdiction, right. Or we do an order determination that does not find a violation and suggests some course of action, whether it's go to EOT or whether it's some other course of action. We find an order determination and we find a violation and we send it to EOT. Or we go to an order determination, we find a violation, we send it to compliance amendments because we think that they have something specific to work out.
Or we make a recommendation. That's what we have been doing. No violation with a recommendation.
Right, and that's done on a piece of paper called an order of determination. And
So is that an order of determination?
right, is that the right terminology? Should we have a different terminology? I mean, it keeps it plain, but I don't want to have, if order determination has a really negative connotation and we're trying not to have a negative connotation, I also don't want to do that.
I think an order of determination is a work of art that was developed solely with the task force. I haven't heard it in any other body. What does it mean? It means you have the title order of determination, and usually it would be an order following a motion. But you have situations where I don't know. I've seen situations where there's no motion that carries, yet there needs to be some type of title to what happened. You got to let the public know that you heard this and something happened. It's not really an order of determination because you didn't determine a violation, or you didn't determine that there wasn't a violation. Nothing was done. I mean, that's the problem.
What if an order of a determination, you're saying this is really just like, an order of determination is only when we find violation? Can we give order of determination no violation, order of determination recommendation?
Yes, you could find an order of determination finding no violation. You can find an order of determination finding a violation. But then you don't have an order of determination where there's no determination. Doesn't make sense.
I think the order of determination is just a sugarcoat, make it look like
It's just our ruling.
rule.
Yeah, it's a determination after hearing. That's basically what it is. It's an administrative determination after hearing.
But wouldn't that provide even an order determination of no violation provide a legal answer to that question to the public of what happened?
Yes, it would.
But to find no violation, we need a majority vote.
Or
Because sometimes we can't get a majority either way, violation or no violation, and that's where we sort of end up in this sort of limbo of maybe that's
should we make
that's where we belong.
a recommendation for what to do if there is no violation to the task force?
You could note it as an item in your minutes about what happened. I mean, that's normally what happens. Usually, an order of determination means that it's going to be going to the parties, and it's going to give them either an answer to the complaint, or it's going to be forwarded to a body to continue work on the case. That's how it normally works. If you have no action taken and nothing happens with it, that's really not
An order of
an
determination.
order of determination.
Okay, maybe nothing needs to be done then.
On cases where nothing is going to be done, yeah.
So basically, if you have no, let's say,
Thing where if there was
no violation, but recommend a letter.
Right, a letter. But
Or some people, I think, refer it to education outreach.
all that has to be done with a majority, right? We can't say, oh, 5 voted this way and I don't know, whatever, 4 voted that way. We didn't agree on something, but we're going to send a letter and, supporting one side or the other, because we can't, because we didn't agree. You know what I mean? Like
Yeah.
we could do an order of determination, just, we could agree to send a letter, but we all have to agree together, or then it becomes like, hey, I can send a letter, you can send a letter. I mean, what is really the word of the task force?
So basically, we would have to have an order of determination on every item, or just make sure it was written in the minutes as no action taken.
It could be no action taken, no formal action taken, but on the violation, on the alleged violation, but that upon recommendation of one of the members suggests that a letter be written, and the task force agrees that a letter should be written, then that could be in the form of a motion saying, all right, we're not taking any action on whether there's a violation, but we suggest that a letter be written. And the body says, yeah, that's a good idea. That would not be an order of determination, but it would be an action item by the body.
I mean, can't a letter of recommendation be an order of determination, or is a certain just an order of determination have to be a violation?
An order of determination is usually spelled out by the facts of the case, the nature of the complaint, the facts of the case, who spoke, what was testified to, and what was decided, and what violations occurred. Now, if there's no violation, it took a formal vote and there was no violation and it was voted that way, then that could all be spelled out, and at the end, the body finds no violation. That's an order of determination. So you could have an order of determination finding a violation, an order of determination finding no violation, but then you got the other area. I don't think an order is appropriate for that.
Well, so Chris was right. It's right here on page 44. It definitely looks like something we have to change, because we have to essentially finish after hearing all the testimony, because the SOTF doesn't necessarily vote on an order of determination. It seems like that's wrong.
So what would your recommendation be in changing?
Well, it's almost like after hearing all testimony, the SOTF shall entertain any motions, because that's what we sort of do, is we stand back and we say, does anyone have, a motion or a way to proceed? I don't know whether we want to say here, which could include an order of determination filing a violation, or a determination finding no violation, or, as we just said, or other directive.
Would you agree, Mr. Lorente? That way we can make it clear to the public and.
What the possible outcomes are?
Do you have anything to add, Chris?
I was thinking through, Mr. Chair, that would it be The appropriate place would be page 45, line 1, I think. Where you can
45
say,
line?
page 45, line 1, say monitored by the SOTF Compliance and Amendments Committee and the EOT.
I think that would be very helpful.
Right, yeah. Or EOT?
And EOT, or and/or slash.
And/or.
Okay. I do think line 3 needs to be changed. So I think we need to give Chris the exact language. After hearing all testimony, the SOTF shall entertain any, I don't know, entertain any something, including but not limited to, order of determination finding violation, or determination not finding violation,
On for number 44.
or other directive measures? Is that,
A list of everything that can happen
right, right,
in clarity.
right. Do you need more specific language in that, Chris, to get it right, or?
Whether they were found in violation, no violation, recommendation, or another directive.
Or other directives that might be written by the chair? Or other directives? Because that's how it's normally worked, letters urging or suggesting, or other directives written by the chair on behalf of the task force.
And then maybe line 6 should be after the SOTF determines a course of action,
Yeah.
the complainant and respondent shall be notified in writing.
Mr. Chair, do we really need to make the change to line 3? Because looking at the hearings, for task force hearings, we've done it without objection during the hearings for task force chair Chu to write the letter. Do we need to enshrine it here?
Well, I think my point is, and maybe it's not that strong a one, is after hearing all the testimony, the SOTF doesn't vote on an order of determination stating whether we entertain the idea of one, and sometimes we get one and sometimes we don't.
The way that it's
I mean,
written,
again,
it
it's-
sounds like we do an either-or thing, and we've been doing more than that. So we're trying to just really clarify it for the public.
Ernie, do you see any urgency in clarifying that?
I think it's good to clarify it. I think this is,
So,
and may issue orders finding a violation, may issue orders finding no violation, or may issue directives written by the chair to the parties to assist in further compliance with the ordinance.
okay. I know it's subtle. Down at line 24, that we were looking in that area earlier, the administrator shall send the order of determination to the complainant and respondent and request a written response within 5 days. We don't actually do that all the time. 'Cause sometimes there's just not, often there's not a whole lot to, I mean, if it goes to CNA, it seems like there's a response needed, but going to EOT, you know, we asked various things out of it. I mean, I think we're specific on what we asked for out of the order of determination. So may might want to,
Well, you could limit it to those sent to CAC, and to those cases that are referred to CAC, we request that a written response be made to the order within 5 days, which shall be monitored by the CAC.
yeah, that sounds good.
And that's simply on the order of determination and not the issue. Yeah, okay.
Yeah. Chris, is there anything else in here that seems like we're either not doing it or is difficult?
The 5 days issue is a little bit difficult, I think.
The 5 days what?
The 5 days requirement is, I think it's a very tight schedule.
Oh, for the respondent party to? Oh, I mean, it's not like we're asking them, well, we're not asking them to, we are asking them actually to turn it over in 5 days, right?
Well, we're asking, how about request a written response within 5 days of the receipt of the order?
Oh, yeah. Yeah, that seems fair, because sometimes it's not that clear.
Then I think we also need to revisit line 14. Within 10 days of issuance of the order of determination. Now, there are 2 dates on the OD. The first one is the date the OD was actually sent or emailed to the complainant or respondent. The second date is the date the task force decided it.
Right.
So which date are we going to use there? I've been using the date it was sent to the task force. I'm sorry, the date it was sent to the
Right.
complainant.
Right, I think,
I think we need some
wouldn't that be what
clarification.
issuance would intend? Or I would be comfortable with that, put it that way. Because I don't think that at the end of every hearing in the task force meeting, we make it abundantly clear about what someone needs to do and what time frame they need to do it in. I think we're sort of like, okay, we got to move on to the next thing. We don't sit down and say, okay, John, you're going to do this in X number of days. And that's what the order of determination does, is spells out exactly what needs to happen. And so if we're asking them to sort of, you know, read into our discussions at a hearing. But you're saying you don't think issuance is enough? Receipt of the order of determination? Or is receipt too ambiguous? Sending of the order of determination?
This is just for like an appeal, correct?
Yes.
So it would be, you're using the, after the 10 days of the order of determination was made, they have 10 days to file an appeal
Yes, I'm trying to change that
to,
to 10 days from the date it was sent out, mailed, emailed.
you
Because
could
for-
do that. That would actually give both parties more time.
More time, yeah.
It would be more beneficial to the public.
Yes.
So I would agree to that.
How would the chair like to word the sentence?
In 10 days of receipt of the issuance, would that be correct? Within 10 days of the receipt of issuance of the order of determination, either the complainant or the respondent may petition the SOTF for a reconsideration only if information exists that was not available at the time of the hearing. Or should we make it more plain to to the receipt to either the complainant or respondent?
wouldn't mix issuance and receipt in the same sentence. It sounds unclear. Within 10 days of receipt of the order of determination.
Okay.
Mr. Chair, in the same paragraph, and perhaps a member of the public would like to comment on it, is for a reconsideration only if information exists that was not available at the time of the hearing. I think, for clarification purposes, that new information needs to be presented, not merely saying that I have new information, I want a rehearing, rather than say this is the new information I have, this is why I want a rehearing. So I've given a reason for it.
Is that covered in an earlier part that when an information about a complaint goes forward, it goes before the administrator, and you review it?
No, I believe that has changed.
Okay. So would we want to add that, or?
You could add a sentence to that section that's, and the petitioning party must present an offer of proof as to the new information.
Thank you, Mr. Morinche.
Anything else in the complaint procedures?
Okay, I mean, line 20 on 47 says, after the public hearing, the task force shall make an order of determination regarding the complaint. Do we need to have that say may, or?
Yeah, what is this document used for, this addendum? Page 46 and 47. I mean, it seems,
That is just recapitulating what is said in front.
do you
Just
use
like,
it?
like a cheat sheet, that's all.
Do you use it for anything?
When people don't want the entire document, they say, do you have something smaller,
Okay,
So that's when we produce it.
okay. Yeah, I mean, it seems like there's a number of issues on page 47, including no periods and a couple of extra holes and stuff. And, but yeah, I guess if it's like sort of a compact version, we should just put may in there instead of try and spell everything out a second time.
Through the chair, which line is that?
It's line 20.
20.
On line 20
On
on
line
page
20, okay.
47. Instead of shall, it would be may.
There's also line 9 can be taken out, and it needs some periods on the end of some of the sentences.
So we're taking these two together. Yeah. I'm going to open up items number 2 and 3 for public comment. Any public comment? Public comment is closed. Matters to the committee.
I don't have anything else that I think needs to be changed. Ernie, Chris, do you guys have anything else that?
Through the chair, none.
Well,
Let's go back to page 40, line 23. And before that, the hearing schedule, line 22. And it says, if the responding city department responded, or the SOTF deputy city attorney does not contest jurisdiction. I don't think I'm involved in that process.
I don't think you can.
Okay, then we can mark that out.
I think maybe they were,
And maybe there was a time when the deputy city attorney appeared for the department, but
oh, okay.
that doesn't really happen anymore.
Well, maybe they meant in your advisory letter, if you were saying we don't have. But that doesn't,
I would, I have no role in terms of contesting or not contesting jurisdiction. That doesn't apply to me. I mean, it would probably apply to an advice attorney that represents the city department. That's the only thing I could think of, you know. I don't know if you just want to strike that portion if we respond to city department.
From all to all these SOTF city attorneys, strike that out.
Yeah.
and I think the A goes away too, doesn't it?
Yes. Yes.
Yeah.
And the do becomes does. If the responding city department does not contest jurisdiction. Got to keep those plurals right. So I'll make a motion to amend the bylaws as discussed.
I'll second that.
Matters, to have a roll call on the motion.
Excuse me, I see one more. It's back to me again. Page 41, line 3. If the responding city department respondent or the SOTF deputy city attorney contests jurisdiction.
So we're going to take that out again.
Take that out again.
Who put it in there?
I don't know.
It's in there with the A too again.
Yeah.
Like it was copied.
Three.
Okay, on the motion to accept changes to the bylaws, Member Chu.
Aye.
Member Chu, aye. Member Chan.
Aye.
Member Chan, aye. Member Johnson.
Aye.
Member Johnson, aye. Mr. Chair, with their 3 ayes.
I'll move to make changes to the complaint procedure as we recommended.
I second.
Do you want to open up public comment to that? Or just?
Desperate for public comment.
Yeah, okay. Okay,
Roll call.
roll call.
On the motion to accept changes to the complaint procedure, Member Chu.
Aye.
Member Chu, aye. Member Chan.
Aye.
Member Chan, aye. Member Johnson.
Aye.
Member Johnson, aye. Mr. Chair, there are 3 ayes.
This time we open up for public comment. Seeing no public comment is closed. Moving on to agenda number 5, any announcement, questions, future agenda items from committee members?
No, so the rule, I've never been on the Rules Committee before. Clearly I was on the Rules Committee before. But this is all the Rules Committee does, right? Is looks at the bylaws and looks at the complaint procedure. Is there anything else that we do?
It also looks at procedures. If there are some procedures that, you would recommend, take a look at this. Can you recommend a procedure? You could do that too. I mean, if it's something that doesn't fall within one of the committees, that's another way the Rules Committee could operate. But usually it's just primarily bylaws and complaint procedures, usually.
I'm making recommendations to the task force, I guess, right?
Right. So this will all go to the next task force and you'll present it, Doyle, and we'll,
Okay.
or if you're not there, actually, Hanley will present it.
What's that?
Will you present our changes to these documents to the full task force at the next meeting? Because Doyle's not going to be there.
Okay. Okay.
Please
Okay.
be aware that this will be on the website 10 days before the meeting.
Great.
Yeah.
There's no further action. I guess we're adjourned.
Great.